Good morning, good afternoon, and good evening, depending on your time zone. Thank you again for joining us during the 2024 Climate Law and Governance Day. My name is Tejas Rao, and I'm Senior Manager with the Center for International Sustainable Development Law. And welcome to this legal roundtable, Reforming Investment Arbitration Practice to Advance Climate Action, hosted by Ethical Instincts. With us, we have here today as Chair Advocate Anusha Jayatilake, an esteemed legal professional and advocate for sustainable development in the Global South. With over 20 years of experience, she has previously served as Senior State Counsel at the Attorney General's Department of Sri Lanka, handling civil and commercial litigation, development contract clearance and negotiations, sovereign borrowing negotiations and appeal clearance, as well as leading high-stakes negotiations and representing the state in complex international arbitration cases. Anusha, the floor is yours.
Thank you, Tejas. Good morning, good afternoon, and good evening, everyone, and a warm welcome to each one of you who is joining us from around the world. We are thrilled to have you here and have such a diverse group of minds gathered here today for this panel discussion. And technology has allowed us to connect from different continents to make this possible. And it's inspiring to see how we can all come together with a shared commitment to address some of the most pressing issues in our field. Our goal today is to explore new perspectives, challenge current practices, and spark meaningful discussion that can lead to a real-world change. Your insights and contributions are what make this conversation valuable. So please feel free to engage, and I encourage you to engage and share your thoughts throughout. So thank you for being here, and let's make this a great session. So today's discussion will first start with the three eminent panelists expressing their views on the topic, followed by three discussants presenting their comments or questions to the panelists, after which we will open it for general Q&A. Please use the Q&A function on your screens and feel free to send in your questions as we progress through the discussion. Now I turn to our first speaker. Today we are joined by one of the world's foremost experts in international investment arbitration, Toby Landau, King's Counsel. With an extensive career spanning over 3 decades, Toby has built a reputation as a leading counsel, arbitrator, advocate, and a thought leader in this field. His experience is not only vast, but also very pioneering. Toby has been instrumental in shaping how we think about arbitration in modern times, especially regarding its role addressing complex global challenges. Toby has served as both counsel and arbitrator in numerous landmark cases, including some of the most significant US-state arbitration disputes before ICSID. Toby has been the prominent voice in reimagining the relationship between investment arbitration and sustainable development, recognizing that our current practices need to evolve to support climate action. As we explore reforms to align investment arbitration with the urgent goals of climate policy, Toby's insights will be invaluable in understanding both legal nuances and practical pathways forward. Please join me in welcoming Toby Landau, KC. Over to you, Toby.
Thank you very much. A warm welcome to everyone. And thank you very much, Anusha, for that very kind introduction. I'm going to begin the session by sketching out the problem that we are facing. The Paris Agreement goal of holding the global temperature rise to 1.5 degrees centigrade requires annual renewable investments to triple by 2030. It requires no new investments in coal, gas, or oil, and it requires positively moving away from fossil fuels. Now, if you put those goals into the context of investor-state treaties and investor-state arbitration, we are faced with two specific problems. One might describe as an offensive issue, and the second one might describe as a defensive issue. The offensive issue is, how do we get to net zero using the investment treaty structure? Does it facilitate that? The defensive element is, how do we prevent investor-state treaties from stopping us getting there? And that is the only element that I'm going to focus on. which is the defensive element. And that is the very significant problem we are facing at the moment. The problem is as follows. We have on the one hand, Paris Agreement targets that are requiring states to achieve certain goals. And on the other hand, we have a pre-existing investor-state treaty structure, a network throughout the world that imposes itself requirements on states to provide various guarantees to investors, and mostly will also allow investors to bring direct claims against states for breach of those guarantees or standards of protection. I want to just begin by tracing very quickly how we've got into this situation. Of course, just to fine-tune the point is that as states take steps to achieve the Paris goals, so they may well lay the ground for claims against them under investor-state treaties. So how did this mismatch arise? And this is a quick, broad brush and therefore inaccurate snapshot as how we got here. Investor-state treaties began in about 1959. That was the first one between Pakistan and Germany. It didn't include an arbitration clause. By 1965, we had the Washington ICSID Convention, which brought into place a procedure for investors to bring claims against states. There followed a massive increase in these treaties. The treaties were designed to promote and protect foreign direct investment between contracting states. Nowadays, the current position, the estimate is probably around 2,600 bilateral investment treaties, together with a network of FTAs and regional agreements with investment chapters. Now, that whole network, which sets up guarantees and protections, was formulated, conceived, agreed, put in place without any regard to the climate crisis. There's no reason why there would have been any regard, because it predates the climate issue, or at least our appreciation of the climate issue. Investor-state treaties were dormant for a long period of time. Nobody really realized they were there. From the mid-1990s, lawyers woke up to their existence, and there followed an exponential increase year on year of claims. So actually, by early, the first rush were NAFTA claims in the early 2000s. And then outside of NAFTA, there were a whole wealth of different claims being brought under a wealth of treaties. And just a few weeks ago, ICSID celebrated the registration of its 1,000th case. With that expansion has come also what may be described as a pushing of the envelope in terms of treaty coverage. This is a function of clever lawyers and, to put it delicately, not so clever tribunals, or tribunals who are not so well versed in public international law. What we have seen is an increase in the coverage of treaties by virtue of an ever-expanding definition of an investment, what constitutes an investment. We have seen an increase in the scope of sovereign acts for which states are found liable. And we've seen an increase in the scope of treaty guarantees as lawyers and tribunals come up with ever-expanding definitions of what they cover. The result of that is that whilst this field might have been conceived of as a system of protection for good old-fashioned investments like construction projects and good old-fashioned state conduct like direct expropriation, nowadays it is very different. It is something of a barometer of world events, and it brings within its scope ever more sensitive areas of sovereign discretion, in particular now climate policy. So the result is that as states exercise their discretion and implement their climate policy, more and more we see claims against those states falling within treaty protection. And that runs the risk of massive claims against states, and it runs the risk of what's called regulatory chill, which is a disincentive on the part of states to actually realize their Paris commitments for fear that they will be sued and held liable with the result of very large allocations of their budget. Now, these claims are coming fast and they're increasing. And some of them now are absolutely directly on point. I'll give you one example, a case called RWE against the Netherlands. It's a case which began, and it has actually stopped, but it's a very good example. It's a claim against the Netherlands brought by coal industry interests. And their case was that the Netherlands' decision to phase out coal was in breach of an investment treaty, because at the time that the coal interests invested in the Netherlands, there was no indication that the policy would change, and phasing out fossil fuels would be phasing out their investment, and therefore they said they were entitled to substantial compensation. Now, there are two aspects to this mismatch. There is a substantive problem, and there is a procedural problem. Let me address those very quickly in turn. Substantively, these treaties contain guarantees of protection, such as fair and equitable treatment, such as full protection and security, such as a guarantee against expropriation, and many others. These tend to be, especially in first and second generation treaties, broadly framed provisions. They provide very little guidance to tribunals. They make no reference to climate change. They make very sparse reference even to environment. In fact, they make reference to very little. All that they set out is whatever was the lowest common denominator that could be agreed between the contracting states when the treaty was negotiated and concluded. This is an area of law where there is no precedent. And so tribunals are given a mandate to interpret themselves what these treaty provisions mean without the restriction of previous decisions. There is huge scope given to tribunals to find breach and then damages, and damages can be massive amounts. There is no appeal, and there is a system of mandatory recognition and enforcement of the decisions. So this is a very, very powerful area in terms of substance. The mismatch comes with trying to reconcile these protections on the one hand with obligations on states under, for example, the Paris Agreement to phase out fossil fuels and to reach the temperature target. How do you reconcile those two different requirements? And there's no guidance at the moment, and tribunals are not told how to do it. And so far, we have the beginnings of what may be seen as worrying jurisprudence, where tribunals have not really been open to the interpretation of treaty provisions against climate norms and requirements and mandates. There are cases, for example, Eco-Oro and Colombia in 2021, where a tribunal has already held that even if a treaty provides for scope for or latitude for a state to implement environmental policy, that would not exempt the state from paying compensation under the treaty to investors. That's a very brief mention of the substantive mismatch we have at the moment. Let me then turn to what I think is arguably more significant, and that's a procedural mismatch. Investor-state arbitration as a process is completely different to commercial arbitration. And the easiest way to understand this is to describe or to conceive of commercial arbitration as a horizontal process and investor-state arbitration as a vertical process. Now, what I mean by that is that in a commercial arbitration, you have two or more contracting parties, may or may not involve a state, but they're parties who are contracting on the same level. They conclude a contract between them. That contract will set out their mutual rights and obligations. And if there is an arbitration of a dispute, the tribunal will be concerned with ruling upon the relations between those two parties. And that's all. The tribunal's determination will only bind those parties. It won't bind anybody else. Investor-state arbitration analytically is totally different. It's more like public law or administrative law. This is an investor suing a state by virtue of the state's policy that hasn't just been implemented necessarily against the investor, but could be implemented for the whole country. And so what the investor is doing is questioning a policy through an arbitral process, the determination of which may impact everybody. Now, with climate policy, may impact not only the whole state, but a whole region. And of course, potentially, it may be of global impact. So the process that's going on in investor-state arbitration is not the same as commercial arbitration because of its much broader significance in terms of its impact. Now, here is the issue. For historic reasons, which are interesting, but I've got no time to go into them, for historic reasons, the world of investor-state arbitration uniformly, has adopted a commercial arbitration procedure for the resolution of treaty disputes. That is a fundamental mismatch. What has happened is that this wider dispute that may have an impact on a whole range of stakeholders has been squeezed into a process that's designed for simply 2 or more contracting parties. That gives rise to a number of problems. Let me identify 3 of them. Firstly, there is a lack of access to all stakeholders. In a commercial arbitration model, the only people who have a right to their day in court, as it were, to be heard, to provide submissions and evidence, are the parties to the contract. If you impose that on an investor-state scenario, you are starting from the presumption that it's only the investor and only the state who will make submissions and adduce evidence. And therefore, even in a climate situation, as with many others, where there may be a whole range of other stakeholders who are affected potentially, who may have information to provide, who may have a perspective to bring to bear, they're not included. They will only be included if the tribunal grants essentially an indulgence. And that is a limited process, experience has shown, for example, of allowing in an amici or an amicus or two or more, or an intervener. That is a process which tribunals treat with some skepticism in practice because they're scared of allowing a third party to come in and exacerbate the dispute, make it more complicated, make it more delayed, make it more costly. And often because the people who want to intervene are actually NGOs with their own agendas, and they are lobby groups. And so tribunals think, well, they're not really objective in any event. So that exercise has not been very productive. The lack of stakeholder involvement was highlighted in the 2023 UN report on ISDS and climate change. You can look at paragraph 24 as a major failing in the current process. The second problem, which is related, is a problem of arbitral tunnel vision. And that is a mindset issue. Arbitrators approach commercial investor-state arbitration through the mindset of commercial arbitration. And that is, they're not minded to take into account any argument or any evidence unless it has been put forward to them by the investor or the state. They take the position of a passive tribunal in a strictly adversarial process where they're waiting to be educated and informed by the disputing parties. And that means that the only information that will be taken into account in their decision is the information that they're provided with. Now, that is problematic. It's problematic because in many, perhaps most cases, the information that they're provided with is imperfect. And that's because of problems of representation. Investors, on the one hand, have no interest whatsoever in providing all the information to a tribunal, especially on climate change. Their interest is to win. And you win by putting forward the evidence and arguments that serve your purpose. So the burden is then on the state side to try and bring to the tribunal all the other information that may tell them about the policy and why it should be sustained. But we all know, and I can't name names, although I'm tempted, that states generally do not represent themselves to the best level. And that's for a number of reasons. There is a pervading level of dysfunction amongst states. There is a lack of institutional memory. There are internal politics. There are budgetary restraints and internal fighting. And there's internal dysfunction generally. And therefore, you cannot rely upon states to represent all stakeholders' interests or necessarily to provide everything to the tribunal. It leads me then, and I'm coming to a close, I promise. It leads me then to the third issue, which is related. The adversarial process leads towards polarization. It is, in essence, a face-off between competing sides. And as the sides continue through the process and travel through the arbitration chronology, they will get more entrenched and more extreme as they resist each other's arguments. Policy is in the area of grey. It is rarely black and white. It's in the middle ground where many interests are balanced. But the net result, I can tell you from experience, when you're sitting as an arbitrator, is that the middle ground is hardly traversed in an arbitration. What you get is black and white, ever more polarized position from the investor, ever more polarized from the state. And therefore, when you retire to your deliberation room, you're not actually assisted in producing the most legitimate, well-informed, robust decision, because so much of the territory hasn't been covered. Now, all of that leads to a number of consequences. It has consequences for the future of investor-state arbitration and investor-state treaties themselves. But overall, that's another point. For climate change, it's pretty disastrous. It means that we have got tribunals who are ill-informed, who are badly placed in order to provide the best possible determinations. And that feeds back into the substantive problem. It tells us that tribunals are not well placed to actually form enlightened interpretations of existing treaty language, to try and move towards some kind of systemic integration where different competing international norms can be somehow reconciled. And ultimately, the risk remains, therefore, that climate policy will be held back by investor-state awards. There will be serious consequences as countries try and move away from fossil fuels, and there will be regulatory chill. And I just finished now by aiming towards a moment of optimism after all that doom and gloom. How do we move forward? Do we just abandon the whole process? Now, that's an easy answer to say, well, just abandon it. It's not a very practical answer, however, because politically it's difficult to do that. And even if it was desirable, and that doesn't take into account the reasons why we have these treaties in the first place, and there are reasons for it, it's not actually realistic because of sunset clauses. It doesn't help us in the short term. A sunset clause will tell you that even if you terminate a treaty, it will exist for 10 years or 15 years. And time is not on our side when it comes to climate. Maybe a solution is to negotiate new treaties with better language. Yes, that is an answer, but frankly, it's aspirational. It takes time to negotiate treaties. And in our divided, ever more divisive world, the ability to actually agree these kinds of treaties will reduce. And one may imagine that since the election in the United States, certain treaties now will be virtually impossible to conclude. And so we're left with the current status. And what do we do? And here is now a moment of optimism. The current treaty regime does allow for a different approach on substance and on procedure. But that in turn requires one of the hardest things of all to achieve. And that is changing mindset. If we were to change the mindset of arbitrators and lawyers, there is nothing in the current rules, nothing in the current treaties that stops them from moving away from a strictly adversarial commercial arbitration model, from moving towards something more inquisitorial, as long as due process is protected, from taking active steps to take into account all stakeholders and empowering tribunals to interpret existing treaty standards in a way that reconciles Paris goals with existing guarantees. It's within our reach. It's simply a question of realizing the emergency and changing people's perspectives. Thank you very much.
And thank you very much, Toby, for those valuable insights. I would say your deep understanding and thought-provoking perspectives has given us all very much to think about. And we appreciate the time and expertise you've shared with us today. It's clear that your contributions will resonate well beyond this session. So now, with that, let me turn to our next speaker. We are privileged today to have Andrew Loewenstein with us, a distinguished attorney and partner at Foley Hoag LLP in Boston. and one of the foremost practitioners in public international law. Andrew regularly appears before the International Court of Justice, Law of the Sea Tribunal, and before ICSID tribunals. Andrew's extensive work at the ICJ, representing states in disputes on issues of sovereignty, human rights, and environmental protection, has placed him at the forefront of tackling some of the world's most critical legal challenges. His experience defending states' interests before ICJ gives him a unique perspective on the intersection of international law, environmental imperatives, and equitable dispute resolution. Andrew has represented sovereign states in some of the most complex arbitration cases globally. He has represented Mozambique and Sierra Leone in the Law of the Sea Tribunal's Climate Change Advisory Opinion, at the ICJ, and the Philippines in the South China Sea Arbitration. And Andrew is also presently representing several states in the climate change-related advisory opinion of the ICJ. Andrew also advises states concerning international investment law, including reforms of the ISDS system, and have served as an advisor to Romania in the UNCITRAL Working Group 3 discussions. Andrew has been a lecturer at Harvard Law School, teaching advocacy before international courts and tribunals. Andrew's commitment to advancing fair, equitable, and responsible arbitration practice has been evident throughout his career. As we discuss reform in investment arbitration and advancing climate action, Andrew's insights into the ICJ's approach towards state responsibility on environmental and human rights considerations provide a valuable lens from which to examine the process of investor-state arbitration. Please join me in welcoming Andrew Loewenstein. Andrew, with the pressing need to support climate action, and in your view, how can ISDS reforms address potential conflicts between investor protections and states' climate policies? And what practical steps can arbitrators and policymakers take to prioritize climate goals within the arbitration framework without deterring sustainable investment?
Thank you very much, Anusha, and thank you for that very generous introduction. It's hard to think of a more important topic than the one that we're discussing today. And it's hard to think of one that's more timely, given the exponential increase in investment arbitration that Toby mentioned, as well as the ongoing COP29 negotiations and with the ICJ advisory opinion proceedings on the legal obligations of the states with respect to climate change that is just around the corner, due to begin in the beginning of December. So I'm truly honored to share the stage with this distinguished group of colleagues to discuss these very important issues. What I would like to do in the few moments I have available is to build upon what Toby said and to begin to address why there might be a kernel of optimism that is warranted in addressing the very serious concerns that he outlined that are embedded in the ISDS system. But what it might be is that because the ISDS system is a system of international law based on treaties, that very character of the system carries with it the seeds of how the problems that he outlined might be addressed. Because public international law, and particularly the law of treaties, provides some of the solutions to the issues that he outlined. The question, or the challenge, is how to convince arbitrators, who are, after all, the adjudicators that are arbitrating these disputes, to adopt the solutions that international law, I would suggest, requires. But before addressing some of those issues, I think it's worthwhile to take a step back and to say a few more words about the nature of the ISDS system as a whole. So as Toby mentioned, it's based on a web of bilateral and multilateral treaties that bestow upon investors from who are nationals of other states certain rights and correspondingly impose upon states obligations with respect to those investors. And the two obligations that are, I think, most pertinent for our current discussion concerns expropriation and the obligation to provide investments with fair and equitable treatment. Now, that's particularly important because in the context of treatment of investment, regulations adopted by states can have impacts. And that's critical because international law recognizes that an expropriation can take place not just via a nationalization of property, but indirectly as well through the regulatory actions of a state, which may have impacts on property belonging to a foreign investor. And so what this means is that there's a potential tension between the obligations that are owed to investors and the rights of states to take regulatory actions that are in the public interest. And these are essentially two competing normative values that are potentially in tension. And so the question, and really the challenge is, how does one balance those competing interests? Now, fortunately, international law provides a significant part of the answer. And what one can look to is the doctrine of police powers, which is a rule of customary international law that recognizes that there's essentially a carve out from the scope of an expropriation for actions taken by states that are bona fide regulations done to protect important public interests that are non-discriminatory and proportionate. And so that provides a very important mechanism by which states can defend themselves against attempts to impose liability for enacting regulations that are in the public interest. Now, one of the cases where this was extensively litigated in an area that I would suggest is analogous to the issues that might be implicated in climate change related regulations was a case that was brought by Philip Morris against Uruguay, where Uruguay had adopted a variety of regulations that impose restrictions on the manner in which tobacco products could be marketed. And I don't need to go into the details about the specifics of those regulations, but for present purposes, I think it's sufficient to say that they impose restrictions on how those tobacco products could be marketed. And so the issue that the tribunal was faced with was whether those regulatory actions constituted an expropriation of the goodwill and trademarks owned by Philip Morris, and or whether it constituted a breach of obligations concerning fair and equitable treatment. Now, the way that the tribunal approached this issue, I think, is very significant and has important lessons for how climate change related regulations might be dealt with in arbitrations. So the tribunal, with respect to expropriation, first examined the question of whether this was a valid or bona fide regulation that was undertaken in good faith. And one of the things that the tribunal looked to was the fact that the regulations were adopted pursuant to what Uruguay saw as not only its national legal obligations, but its legal obligations that were imposed by virtue of its membership in the WHO Framework Convention on Tobacco Control. In other words, the fact that Uruguay was undertaking these measures pursuant to international legal obligations was very strong evidence that they were bona fide regulations adopted in good faith to achieve an important public end. Additionally, the tribunal looked to the question of whether the regulations were arbitrary. And again, what the tribunal examined, among other things, was whether the regulation was based on evidence. And similarly, it looked to the evidence that had been assembled by critical international organizations, for example, the WHO, as well as the Pan American Health Organization. That, I think, has important lessons for climate change regulations, which we can get to in a moment. So this brings me back to the question that was asked. So what steps can arbitrators take, and what steps can policymakers take in order to prioritize the achievement of climate-related goals, but still operating within the arbitration framework and in a manner that doesn't deter the achievement of sustainable investment? Now, turning first to arbitrators, one of the most important things I would suggest is that due to the fact that the relevant legal obligations are contained in treaties, arbitrators must apply international law to the interpretation of those legal obligations. And that includes applying the rule of treaty interpretation, that the provisions of a treaty must be interpreted in light of any rule of international law applicable to the relations between the parties. That's a rule of treaty interpretations contained in the Vienna Convention in Article 31(3)(c). Now, those rules include rules of customary international law. And those customary international law rules include the rules relating to the police powers doctrine. So what you can see is that embedded within the rules of interpretation is a reference, in essence, to the police powers doctrine that arbitrators should look to when determining whether an obligation, whether a regulatory action by a state has breached an obligation under a bilateral investment treaty. And you can look to the Philip Morris case again to sort of see how this can operate in practice. As I mentioned before, the Philip Morris Tribunal placed significant weight on the fact that there were legal obligations that Uruguay was attempting to fulfill through the enactment of its regulations, and those legal obligations were contained in multilateral treaties. One can easily draw an analogy to the types of legal obligations that are contained in the UNFCCC, IFCCC, the Paris Agreement, as well as in overarching obligations of due diligence that are contained in customary international law. And again, turning to the next question of whether a regulation was arbitrary. Here, the scientific evidence is really critical. And entities like the Intergovernmental Panel on Climate Change and its assessment of the best scientific evidence, including especially what is needed to achieve the temperature goal of minimizing the increase in temperature to 1.5 degrees above pre-industrial levels, is the sort of benchmark that a tribunal can look to determine whether a regulation is arbitrary or not. And just to say a few words in conclusion about policymakers, due to the fact that arbitrators should look to these types of institutional views concerning legal obligations and the evidence, it's absolutely critical that international organizations provide the type of evidence base that states can draw upon in explaining to arbitration tribunals why its actions are bona fide good faith acts of regulation and why they are based on sound evidence and therefore aren't arbitrary. In the interest of time, I think I'll just pause there and revert back to the chair.
Thank you very much, Andrew, and thank you for your perspectives. We'll come back to you in with our discussions, questions, and in the general Q&A. I now turn to our third speaker. Today, we are honored to welcome Professor Sornarajah, a preeminent scholar in international investment law and an influential voice in critiquing the traditional frameworks of investor-state arbitration. Professor Sornarajah, currently an Emeritus Professor at the National University of Singapore, has authored seminal work that has reshaped academic and practical perspectives on investment arbitration. His groundbreaking critiques have sparked essential discussions around sovereignty, equitable treatment, and the rights of states in protecting their own development and environmental goals. As we gather to discuss reform in investment arbitration to support climate action, Professor Sornarajah's deep insights into the legal structures, that govern these disputes and his advocacy for a system that truly serves the public good will guide our understanding of how arbitrations can evolve to meet global climate imperatives. His expertise is indispensable to our conversation today. So please join me in welcoming Professor Sornarajah. Over to you, Professor.
Well, thank you very much, Anusha. It's pretty evident from the speeches of the other speakers that there is a deep malaise with investor-state arbitration arising from investment treaties. And it has already been mentioned that there is a huge tension that has arisen between international climate law and the international law on foreign investment arising from investment treaties. This tension I see as arising from a clash between two regimes. The regime of investment arbitration, of course, arises from the greed of multinational corporations to ensure that their assets and property are protected wherever they are taken, and that even when measures are taken to advance the protection of the environment of a whole state, those measures could be sanctioned through arbitrations that result in heavy damages, sometimes running into billions of dollars. On the other hand, there is emerging an international climate law, struggling to emerge an international climate law, which seeks to ensure that calamitous and catastrophic events do not affect mankind. It was evidenced during the Spanish floods that hundreds of people died as a result of the consequences of climate change. So this clash is what dominates this area of the law. And it is very difficult to think in terms of any reform that would take place in the area of investor-state arbitration. Armies of lawyers are involved in protecting the system. It is a system that gives rise to mercenary interest in a whole legal profession that is devoted to this area. There are arbitrators, of course, who would not want the system to die because it is the cow that they milk for much profit. So in those circumstances, whatever reforms that are made, like for example, the bringing about of balanced treaties that give defenses to measures relating to the environment, all these efforts that have been made at reform have failed simply because of the fact that arbitrators and lawyers are willing to accept methods of circumventing the reforms that are made. I think Toby referred to the Colombian case, Eco versus Colombia, which was the first instance when one of these balanced treaties containing a defense of environmental protection was made, but we see that the arbitrators were able to circumvent this defense and give priority to the interest of the protection of the mining investment that had been made. So we see that on every occasion where a reform is attempted, the reform is circumvented by arbitrators. Reference was also made by Mr. Loewenstein to the idea of regulatory expropriation and regulatory expropriations or the use of police powers not being subject to compensation. But even such a rule, of course, has been subjected to the rule relating to proportionality, idea that is borrowed not from customary international law, but from the decisions of German courts and from the decisions of the European Court on Human Rights. So wherever there is a reform that is made, and many of the reforms that are made are in fringe areas, like the ones that Anusha is thinking of at the moment. If reform is made, those reforms are subverted by arbitration tribunals. So in that context, then, there is very little prospect of reforms of the existing law succeeding. Contrary to what Toby has said, I would suggest that this Gordian knot be cut and that treaties be terminated, including the sunset clause, with the agreement of the other party to the treaty. So what at the moment, obviously, these treaties are made on the fraudulent assumption that they lead to development in the poorer countries of the world. This is not a provable assumption. The economic literature in economics would suggest that there is no evidence at all to show that treaties do lead to development in the poorer countries. Rather, they protect multinational companies that profit by disemboweling the natural resources of the states, which suffer the consequences of pollution that arises from the exploitation of their resources. So the termination of these treaties is of great need, and that international climate law can advance only in those circumstances where such protection and assistance is not given to those multinational corporations which operate in the natural resources sphere. So there's no disadvantage that occurs because there are other systems of protection. The treaty system itself is relatively new, though Toby said that the first treaty arose in 1959. Really, the system starts in 1991, when unilateral recourse to arbitration was accepted in a case arising from Sri Lanka, WAPF versus Sri Lanka. The decision was in 1991. So this idea of ISDS is relatively recent. It's only about 34 years old. So dispatching it to the wilderness will not will help the developing countries. And of course, as I said, there is no vacuum that will be created if this system is terminated, because customary international law of diplomatic protection would still continue to exist. There's still the avenue of state-to-state arbitration. Besides, I would say that there is a powerful alternative that is being created at the present moment. We see that there is, as Mr. Loewenstein pointed out, an advisory opinion that is due to be delivered by the International Court of Justice. The case is to be heard on the 2nd of December of this year. But the question of the responsibility of states to protect the environment and enhance the creation of international climate law has already been answered by other tribunals. There is ITLAS tribunal, an international tribunal on the law of the sea, which has dealt with the obligations of states to protect against the rise of sea levels that would affect small island countries, which recognizes again the duty of states to ensure the protection of the marine environment. There is case law also in the human rights sphere, and most importantly, this case law equates the protection of the environment with the whole jurisprudence relating to human rights. I think that the fact that there is this equation that is being made would give rise to an alternative system dealing with foreign investment that would be of greater importance to developing countries. So the idea that the protection of the environment includes the right to life and the right to good living conditions is inherent in the notion of environmental protection. So the case law supports this idea of the drawing of an equation between the right to the environment and the right to life and living conditions. We have the case of Loewenstein versus Perera, which was decided by the Inter-American Court on Human Rights, making this equation that a good environment, a clean environment, is a necessary condition for the living of a good life and the protection of the right to life. There's also a case decided by the European Court of Human Rights, which stresses the idea that older people who brought this action would require the state to protect them from climate change, simply because of the fact that being older people, they would not be able to resist a harmful environment. So there is a duty on the part of the state, according to the European Court in this case, to ensure that there is a clean environment. More significantly, of course, there are a series of decisions of local courts, of domestic courts, which emphasize the need to draw a connection between the right to an environment and the right to life and the right to good living conditions. Now, Judge Janak Silva has delivered an important judgment on the Seychelles Supreme Court as a foreign judge, which emphasizes this the drawing of this link. There are, of course, cases decided by Brazilian courts, the Indian courts, and also by the Sri Lankan court, which draw this parallel. I see that my 10 minutes are up, and let me say that what we need today is an international law based on need that protects human life, promotes the interests of the global community to a good living environment, and not a law of greed that protects multinational companies, the few rich in the world. The need of the world is the protection of the many and the protection of their right to live in a good environment. Thank you very much.
Thank you very much, Professor, for sharing your profound insights with us. And I think your extensive experience as both an advocate and an academic, you brought a depth of knowledge that only years of dedicated work in this field can offer. So I'm very grateful and truly appreciate your contributions. So with that, let me move on to the second segment, the discussion with the panelists. We start the Q&A with our discussants, and today we have three discussants who are quite learned and eminent in their own right. I first turn to Justice Janak De Silva. Justice De Silva is a justice of the Supreme Court of Sri Lanka and a judge of the Court of Appeal of Seychelles. He was formerly a senior deputy solicitor general at the Attorney General's Department of Sri Lanka and has worked on ICSID arbitrations, drafted model BITs, and engaged in ISDS reforms. Earlier this year, Justice De Silva delivered a judgment on states' responsibility with regard to the environment. Justice De Silva will present his comments or question to Professor Sornarajah. Over to you, Justice De Silva.
Thank you, Anusha. Thank you, Professor Sornarajah, for your insightful views. As you correctly pointed out, there is now a tendency to go upon human rights obligations to underpin, upholding, to take positive steps towards protecting the environment. And the case that you mentioned in Seychelles was very much underpinned by the constitutional provisions of the Seychelles Constitution, which of course is quite new. But although international law has been slow to pick up on the need to protect the environment, you will no doubt agree that for more than 2,500 years, the major religions of the world, Christianity, Buddhism, Hinduism, Islam, has unequivocally recognized the fact that we humans are trustees of the universe, which means the need to protect the environment for future generations. And that, in my view, is one of the factors which was missed by the drafters of the ISDS system, because I see two birth defects in the ISDS system as we know of it today. Firstly, it is a question of depoliticization, which Toby has so eloquently touched upon in his Alexander lecture in 2023, and I did not tread on the same path. But the second birth defect that I would like to point out is that when one compares what the drafters of the General Agreement on Tariffs and Trade did in 1947 by recognizing policy space for the states to take actions to restrict trade, the freedom of trade in the interest of plant and animal health and the environment. They saw the need to protect the environment as at that point of time in the face of liberalization of the trade. But that is something that the drafters of, or the people who conceptualized the ISDS system overlooked by not recognizing it specifically, so that the governments were in a position to maintain the policy space in the face of need to take measures to protect the environment. I think that has contributed to the mindset that Toby referred to of the arbitral panels. I think that has contributed to the point made by Professor Sornarajah about the exploitation of the ISDS system by some stakeholders. And I think in a way, it has also led to the approach taken by the arbitrators and the practitioners when it comes to the ISDS system. But I think what is a very significant development is the proposal made by 3 Pacific nations to amend the Rome Statute to make ecocide as the 5th crime that the ICC can take cognizance of. And maybe I could ask you, does it really mean that such extreme steps have to be taken for the ISDS system to be awakened to the need to protect the environment, or is it something that the countries themselves can take without going down that route? Thank you.
Well, thank you very much, Judge Silva, for your question. Ecocide is an interesting concept, but the fact that you have to invoke the jurisdiction of the ICC is significant. The notion of curse is rhetorical more than practical, because we see that much is spoken about the trial of war criminals belonging to certain countries, but the eventuality of this resulting is going to be very problematic. So a defense, a crime could be created, and there could be an impetus for the creation of the crime. But the answer, the practical possibility of there being a prosecution for ecocide of, shall we say, a large multinational company or CEOs of large multinational companies would be problematic at the present moment. Rather, I see a greater possibility in this idea that you mentioned, that we should extract this notion of a specific rule of mankind owing a duty to nature from the religions of the world. I mean, why say that only the legal systems of civilized nations contribute to international law when you can query the rules of international law from a multitude of sources? I also am encouraged by your judgment in the Seychelles court of the idea that you could receive many of the conventions into domestic law, and that domestic court's judge could function as an international judge and interpret these treaties. So that's going to be the way forward because of the fact that there are many courts, including the Supreme Court of Sri Lanka in the Epavela phosphates case, in the Chunagam oil case, in which the Supreme Court led the way in the usage of international conventions in proscribing events that were taking place inside the territory of Sri Lanka. So my view simply is that your idea of ecocide being recognized as a crime is a good one, though I am skeptical of it happening in the near future. Policy states, something that you mentioned, that's referred to in the newer treaties. Some of the so-called balanced treaties contain words that are taken from the old GATT formula and are used as defenses. My view is that using them as defenses is no good, because what the state is intent on doing is the protection of the interests of its people. It is seeking to defend its people against measures that a multinational corporation takes. Why should it be a defense? It should be a right of a state. After all, we say in Latin, salus populi suprema lex. So if that be so, why should it be a defense when a state takes measures to protect the health, welfare, and morals of its people? Thank you very much, Judge, for that question.
Thank you to both Justice Janak Silva and Professor Sornarajah. I now quickly move to our second discussion today, Dr. Avanti Perera. Avanti is a Deputy Solicitor General at the Attorney General's Department of Sri Lanka. Avanti is and has been an integral part of the Attorney General's team of advisors in constitutional matters and matters regarding states' international responsibilities and human and fundamental rights cases filed against the state. Avanti is assigned the task of preparing Sri Lanka's written submissions for the ICJ's advisory opinion on the state's responsibility in respect of climate change. Avanti holds a PhD from University of Oxford. Avanti, over to you.
Thank you, Anusha. And thank you very much to the speakers before me for all the insights and the different perspectives. So my question really to you, Andrew, is that, yes, we all agree climate law is developing as we speak, quite apart from the ICJ advisory opinion on obligations of states to ensure protection of the climate system from anthropogenic emissions of GHGs, which the world is, of course, waiting in anticipation. The Hague Appeals Court made a ruling just a few days ago, which overtly does not advance the cause of climate justice, but nonetheless recognized the concept of state responsibility for climate change. So although the Royal Dutch Shell PLC won an appeal against a landmark judgment, which had ordered Shell to accelerate efforts to reduce carbon emissions, that judgment does in fact recognize that there is climate law responsibilities under international law. So in this context, you had also mentioned the possibility of interpretation. So what I want to really ask is, because Toby referred to a changing of the mindset on the one hand today, and Professor Sornarajah on the other hand has this polarized view that reform is actually not a potential. Do you see, with your experience, if courts worldwide and the ICJ continue this trend of recognizing state responsibility for climate change, do you think that things like FETs, fair and equitable standard, could be approached in a different way. You did mention a systemic integration, rules of treaty interpretation, and even going beyond. Do you see potential to raise jurisdictional objections, make counterclaims based on states' responsibilities to mitigate climate change? So essentially, my question is, to take a phrase from post-colonial literature, can the empire write back in the language of ISDS? And do we see some light at the end of the tunnel to bring some kind of middle ground on these issues? Thank you.
I certainly hope so, though much will depend in any given case on who the arbitrator is and the extent to which the arbitrator is open to these types of arguments. But with specific regard to the promise that the ICJ advisory opinion has as it might relate to how tribunals interpret and apply FET obligations, I think there's several areas where the ICJ opinion could be very valuable. The first would be to confirm, as ITLOS previously did, that the IPCC represents the best available science. So to really put to rest any question that the findings in that regard are the gold standard as to what the current state of science is. But also to adopt the position that the temperature goal set out in the Paris Agreement informs the content of the international law due diligence obligation. And relatedly, to apply the principle of systemic integration to harmonize international law obligations under different bodies of law. So the two major areas of law where the ICJ is being asked to interpret and apply are both international environmental law and international human rights law. And the court can and should apply the principles of systemic integration to harmonize the obligations that are set out in those different bodies of law. If that's the case, one could also easily make the argument that the same principles of systemic integration should also apply to harmonize obligations states have with respect to international investment law. So I think those are key areas where the court's forthcoming opinion could be very valuable. I know we're very short on time, so I think I'll leave it at that.
And thank you very much for your perspectives, Andrew, and Avanti, for your question. Unfortunately, we're at the end of our session, the time allocated for us. So I can see a number of questions in the Q&A, but the time does not permit us to go into them. But thank you very much for your interest and sending us the questions. And I thank all the panelists and the discussants who have joined us today. Thank you very much to everyone from all over the world who has joined. And hopefully we'll meet again discussing these important topics on another day. Thank you.